Okay, well, I'm pleased to present the Green Law Group's New Construction Laws webinar for 2021. My name is Stephen Sanders. I'm an attorney. I represent contractors and other real estate professionals in construction transactions and disputes. We have a pretty vibrant practice here in real estate and construction dispute and transactional matters, and we also do employment law primarily for contractors. We're kind of your one-stop shopping for most of the things that you'll deal with in your day-to-day lives as contractors. We're going to go through and first thank our sponsors. I want to encourage all of our clients and others that may be participating in this webinar to make sure that you educate yourselves in the proper types of construction notices and licensing requirements and networking availability that each of our sponsors will provide. And easy law construction notices, it's very important that you preserve your rights as a contractor for payment. It's good for you to do that. I encourage you also to make sure that you visit the Builder's Bookstore. It's a smorgasbord of wonderful tools for you as a builder to make sure that you are up to date on code requirements, licensing requirements, and maybe you want add another a license category to your capabilities as a construction company. I'm not giving anybody any specific legal advice here. This is not a presentation for legal advice. I'm giving you general information about new statutes and court rulings. You know, everything that we do is fact specific as lawyers. So, you know, if you would, this will raise questions for you. You can feel free to reach out to myself or the lawyers here at the law firm, and we will be happy to answer your specific questions and make an effort to apply, you know, these new codes and laws and changes. As I indicated before, we're focused primarily on the contractor work. That at least is my focus as an attorney. I myself am a licensed contractor. I was a project manager for many years. I was an ICC certified residential building and electrical inspector at one point. So, you know, we have a pretty good understanding of the practical applications of the laws here, and I think that we really serve our clients well in that regard, or at least that's been our feedback. 7 attorneys currently working at our firm, any one of whom can help you. For 2021, laws passed in 2020, a major change is in contractor licensing. They've added a new building contractor classification in Senate Bill 1189. It's for residential remodel contracting. And I think that the impetus for that was that there were concerns, particularly with fires and floods, you know, in California, that there were not enough residential remodel contractors available to people. This is really kind of a beefed up handyman type classification. Just like the regular B classification, you need to make sure that you are operating in 3 unrelated trades. Here, the unrelated trades for this B2 classification are actually expressly written out. It's drywall, carpentry, flooring, insulation, paint, plaster, roof repair, siding, tiling. You're also allowed to do installation of MEP, mechanical, electrical, and plumbing fixtures, but you're not going to do the runs or the connections. You're not licensed to do that. You need to hire licensed and qualified subcontractors for that work. The home improvement categories are expanded here to include properties damaged in a disaster zone, and you know, there are certain things here, clarifications in what unlicensed contracting activities can be prosecuted. Another good thing that happened last year, this is something that we've been dealing with for quite a number of years now, where we have very, and we're going to get into those in more detail next. We have very, very stringent licensing laws in this state, and disgorgement penalties under Business and Professions Code 7031, which basically, if a contractor is trying to get their license processed and they renew, the CSOB has been somewhat, I would say, overburdened of late, given the COVID situation, and there have been a lot of delays in getting licensing through. This new law creates a retroactive reach back to the date due, so that we're not unlicensed during any period up to 90 days, as long as you follow the provisions here of Senate Bill 1474. If you have any issues with licensing and getting renewed, you should call our firm quickly, get right on top of it, because 90 days will tick away in a big hurry. A case came down last year along those same basically related issue to disgorgement claims. There had been a question among attorneys about the statute of limitations for disgorgement claims. What is disgorgement? If a contractor is found to be unlicensed in a period of, during any period in a project, this would include where a contractor failed to put or to cover a worker with workers' compensation insurance, one of their employees, then you're unlicensed as a matter of law in that regard. So if you're unlicensed at any point, the penalty was you could not bring any claims to recover monies due under 7031, and also you were being made to, and are being made to, disgorge all of the labor and materials that you've been paid on a project. It was a very harsh penalty when it was originally construed, but there had never been any direction by the courts as to what the limitations deadline. The statute was silent on that. There were a lot of conflicting ideas about that. So that's been resolved, at least in our local second district here in Los Angeles, Ventura, and Santa Barbara areas, San Luis Obispo. The court came down and said it's a 1-year penalty limitation for the statute of limitations. So how is that calculated? Well, the court's guidance in that, you had a direct contractor here, Suffolk Construction, who was doing work on behalf of the Eisenberg Village. So the measure was from the date of completion of the work. And the court gave us that indication, 90 days from completion or cessation. There is still some question as to whether or not how you would apply this in the case of a unlicensed subcontractor. Like if this was an issue with Suffolk Constructions, hypothetically, subcontractor was unlicensed, what was the date of completion? What I would encourage anybody, particularly if they're a homeowner, or if they're a contractor who is going to sue a subcontractor on license issues, that you monitor your subcontractor's license status or your contractor's license status, depending on their website. Check it periodically, certainly check it before you hire them. And if you determine that there is somebody is unlicensed or is putting workers on a job that don't have workers' compensation, that you should seek to enforce your rights if you're going to under 70/31 as quickly as possible, because that year may run sooner than anybody expected. There were also some laws that came down related to health and safety, and particularly in the COVID environment. Employers are now required to provide written notice to employees exposed to COVID-19. That's AB 684. That's AB stands for Assembly Bill. The employee notice must include the same information as the Cal OSHA Form 300. And Cal OSHA can now restrict access to work sites, machines, devices, apparatus, or equipment for dangerous conditions. It's another change. We also have Senate Bill 1159, kind of along these lines. There's a rebuttable presumption that if an employee tests positive for COVID-19, that they did so while working for their employer. That rebuttable presumption continues through January 1st, 2023. Well, what is a rebuttable presumption? Well, it's presumed that they contracted COVID unless you, the employer, can demonstrate factually that they didn't have it or didn't catch it at your place of work. That is a difficult threshold. So, you want to make sure that you're documenting your COVID cases very carefully, and that you're following all of these guidelines. If you have questions about COVID-related guidelines, please call our offices here and speak to the attorney mainly handling that for us is Matthew Bechtel. Residential construction changes, related, and what this really relates to are home improvement contracting changes. There was a practice of PACE assessment contracts where prepayment penalties were being applied. Those are now prohibited, and they also can't do PACE assessment contracts on properties with reverse mortgages. That was messing things up. PACE financing and estimate disclosure must be provided in paper form. To be quite blunt, I'm not a huge fan of PACE. I think that there are been a lot of abuses in PACE. If you were in the PACE business, I would strongly, as a contractor, I'd strongly encourage you to contact me or the other attorneys here for us to give you a little bit of scrutiny and assistance in setting up your PACE operation, so that you are not going to run afoul of your local district attorney, et cetera, in these matters. These are, you need to be very careful. They also, on home improvement contracts, and this is very important for all of you who are residential remodel contractors, you need to update your forms, and you should contact our office to do so for your home improvement contract. There is a new law, the 3-day notice of right to cancellation and the acknowledgement for that notice, that has been extended now for seniors over 65 years of age from 3 days to 5 days. The 3 days still apply to those 64 and under, but for seniors, it's now 5 days, and your documents, your home improvement form should reflect that. As far as public works, there were actually quite a few more public works projects changes this year, other than the two I've identified here. There's a safe harbor from prevailing wages on projects where the public subsidy is less than $600,000 and 2% of the project cost. Projects advertised for bid are awarded on or after July 1st, 2021. The safe harbor will apply to. There's also, there's changes related to the Veterans Business Enterprise certification amounts paid. What state agencies can withhold in a payment dispute. Those are two that, that's SB 588 and AB 2231. Those are two of several. If you do predominantly public works type projects, I would encourage you to call our office and we can go over the more extensive changes last year on that particular topic area. Something else happened last year, which has created a great deal of confusion, not only for the contractors that we deal with, but also their attorneys. The classification system for what is an independent contractor did create a change in how we approach that, and it is somewhat more stringent, or at least it's better defined how to approach it. Just as a baseline, when you're evaluating whether a construction worker is an employee or an independent contractor that you've hired, the threshold, the first place you look is Labor Code Section 2750.5. And basically that is indicated that there are two sets of presumptions. There's a rebuttable presumption and there's a non-rebuttable presumption. It's a dispositive presumption. There's a dispositive presumption that if the work that the worker is performing requires a license, that if they are unlicensed, then they are a employee. They are not an independent contractor, okay? And then AB 5 was passed last year, which then creates a three-factor test. Even where that individual may be licensed, they need to be, in order for them to be a independent subcontractor, therefore truly an independent contractor, right? They need to be free from the control and direction of the hiring entity. They need to be performing work outside the usual course of an entity's business and customarily engaged in an independently established trade, occupation, or business of the same nature as work performed. Well, okay, that's tough because, you know, there are a lot of, even B contractors have sub-generals, and subcontractors hire subcontractors, and often they perform in the same work capacity. The burden of proof is on the hiring contractor. So let's say you were hiring somebody that is working in your usual course of business and you can't meet this test. Well, there's an exception to this three-prong test built into AB 5, and that is a licensed worker is a subcontractor if a contractor can establish all of the following: that the subcontract is in writing, so you need to have either a master subcontract or a regular project-specific subcontract. If you have a master subcontract, please have a project addendum for each project so you can define that work scope specific to a project. If you need assistance in that contracting, that's what we do all day long for our contractors. Please reach out to us. You need to make sure that they are actively licensed by the CSLB and they have their bond. If they're exempt, that means they cannot be hiring any employees and they should not be a corporate entity. They should be an individual if they're claiming that exemption. Otherwise, if they're a corporate entity, they should have a zero employee policy if they're the only one employed by that corporation in a subcontractor capacity. As far as the next prong, this is where I think everybody's going to get messed up in qualifying their sub or sub-general, you know, or maybe they hire their superintendent or managers who are licensed on an independent contractor subcontract basis, you know, as construction managers. That subcontractor needs to have a local business license or tax registration if it's required in the jurisdiction they're in. If you have questions about that or don't know what that means or how to get that done, or whether in fact your jurisdiction requires it, contact us and we can assist you in researching that. They need to have a separate business location. Typically, if it's an individual, I would presume that their license would be at their home, or maybe they have set up some other business location, but it can't be that the contractor is hiring their sub-general or sub-sub and using the same principal place of business and reporting that to the CSLB. That needs to be a different location. In terms of their service, they need to have the right to hire their own assistant. So typically, if you're going to have an assistant to the superintendent that you've hired on a subcontract construction management basis, they need to be hiring their own people direct and running them on payroll and providing workers' compensation insurance for them, typically independently. The other one that's very important here for a sub or a sub-general or just any old subcontractor is they need to have an independent indemnity clause in their master subcontract, or they need to have errors and omissions, maybe a construction management rider if they're acting as a superintendent or manager. We can assist you in setting those kinds of things up, but you need to make sure that those contracts include that and that they actually follow through and fulfill those obligations. Should also have their own general liability policies for insurance. And also that the subcontractor is customarily engaged in business of the same nature of work performed. So, typically if it's that's going to be an easy threshold to meet. Otherwise, if you're not dealing in the realm of a subcontractor and you're dealing with a rebuttable presumption of Labor Code 2750.5, assume that if the work doesn't require a license, which is a very limited category of work, it's a guy pushing a broom, okay? There are a few other things that we can talk about, laborers, essentially unskilled laborers, or administrative staff. Then you have to go through the rebuttable presumption factors. They're essentially the Borello Test, which most independent contractors in the state, employers have to meet in order to determine whether there's 13 factors that qualify you. Matt Bechtel in my office is really good with these kinds of things, and I would encourage you to reach out to him if you're getting into any of these areas and you have concerns. I'm going to go through a few cases here that I wanted to highlight. They're not the sum total universe of all changes, but they are each of the two case law, but they do impact our contractors. This Caliber Paving versus Rexford case, the big focus here is a lot of you contractors, I'm not going to read through it all. You can ask for the materials. I think we'll send it out to the participants automatically. If anybody later on is reviewing this and you want these materials, you can feel free to reach out to us and we'll provide them to you. But I'm going to speak generally to what the problem is and then what the solution was for each of these cases. The problem was essentially that owners would come in and start directing the contractor to fire their subcontractor or would interfere with the subcontractor's work. What contractor hasn't dealt with a problem owner before? Well, in this case, the subcontractor sued their contractor for breach of contract, but they also sued the owner for intentional interference with contractual relations. And the court found they held that the non-party to the subcontract owner, Rexford, was not immune and found them liable for interfering with those subcontracts. And that had been a big argument for owners' counsel in years past. And I'm happy to see clarification of that. Even though, they're a third-party beneficiary, the owner may be a third-party beneficiary, they still should be punished for unreasonably interfering in those relations and doing so with intent. Moore versus Teed, this was another interesting case. Here, basically, a real estate agent who ran a construction business basically promised to do $900,000 on a multi-million-dollar home in San Francisco, and made a hash of it. There were fraudulent misrepresentations about their qualifications and other things that led them, the court held that, and the trial court found, that led them to enter into a contract with Teed where he was, probably demonstrably unqualified. And so the court held that the benefit of the bargain damage as well as the out-of-pocket expenses are the measure of damages for the fraud remedy, which clarified some other issues previously. They also ruled on Business and Professions Code 7160. I was happy to see and applied attorney's fees for fraudulent inducement to a home improvement contract. This will be a case that we return to for homeowners, and the Homeowners Council will return to whenever there's substantial misrepresentations to a homeowner in the inducement on a home improvement contract. There's also RGC Gaslamp versus Ehmcke sheet metal. This is we as a practice at the Green Law Group, we're a mechanics lien engine, so to speak. We work with Easy Law, and we generate, which is a separate business, but we generate foreclosure lawsuits on mechanics liens to try and get contractors paid. And one of the things that has come up over and over again is, well, you had some technical violation, or maybe you've overstated the value of the lien, or there's some other issue here, and you believe you recorded a invalid lien, and now you're exposed to slander of title, etc. This court, held directly on point to that issue, and even where there's invalid mechanics liens and no basis, even for maybe potentially for the contractor for one reason or another, to have believed even that lien was valid for one reason or another, they're still engaging in a protected activity under Civil Code Section 47B, and they're not going to be held liable for slander of title and invalid lien claims, other than as included in the mechanics lien laws expressly for those remedies. Another case came down was Sieg versus Fogt. I'm probably butchering that, but I'm going to call it Fogt. This is a case where that comes up a lot, where we have, on the one hand, we have administrative law remedies related to contractor state license board actions for citations, accusations, and that is an administrative process in front of an administrative judge, and then we have, separate from that, the civil litigation through the superior court system, or maybe the federal court system, depending. And so the administrative law part of it is on licensing and licensing enforcement. And one of the things that comes up is sometimes a homeowner or a property owner will come to a contractor and say, hey, I know this is not what the code requires, but this is what I want. And then the contractor says, okay, we'll sign a waiver here. Maybe even you'll indemnify me and hold me harmless. Go ahead and do this work, okay? And the Court of Appeal in this case said, if you do that, while it may be applicable in your civil action, that may constitute a waiver of a private right of action. The Court of Appeal's job and the licensing bureau here is charged with maintaining public standards, and that waiver is not in effect. So understand that if your client comes to you and says, I want you to do something in violation, material substantive violation of the code, you may still be responsible to the CSLB if later there is a complaint by that homeowner or property owner. And, you said, oh, well, I got a waiver here. Yeah, so what? Okay. So that's where that ended up. And that solved kind of an interesting dilemma that we have been dealing with for a number of years. SB 610, this affects bonds, and I would strongly encourage license holders to pay their construction claims. If if now, according to SB 610, your license will be automatically suspended if a judgment is entered against you or any of your CSLB personnel of record, okay, which can also reach out into RMOs who may hold other licenses too. It may in fact impact all the licenses that RMO or RME, well, it wouldn't be an RME, but an RMO may qualify for. They're going to conduct a study whether they should increase the $15,000 contractor bond, increase that bond amount, and they're giving the CSLB the latitude now to require a greater bond, a $30,000 bond for those who have been convicted of a license law violation. I suspect that will also apply in most settlement agreements for citations and accusations if you settle them, but that remains to be seen. Low voltage C7 contractors are no longer charged $20 when renewing an active license. I'm not clear what the story was on that one. That was one I didn't know about, but I'll go back and look at it and see what it meant. I apologize, but I do know that one of the things about this particular the bond issue is I felt for some time the $15,000 contractor bond was probably too low, but what I would encourage is a reduction if they were going to increase it in the RMO bond on top of it. And I think that the CSLB should probably take a long look at the labor and employment bond for LLCs, limited liability companies in California, and the application of that. Hopefully they'll take a look at that as part of their assessment too, but we'll see what they do. There was also an amendment to the Dig Safe Act. I'm not going to dig too deeply into that, but one thing I'm going to point out is, this complicated name, California Underground Facilities Safe Excavation Board, is now simply the Dig Safe Board, okay? And your job is, as an excavator or general contractor, either an A or a B, or anybody, or a grading contractor, anybody digging, you need to, if you do discover an issue in the dig, or you cause damage to existing improvements in the dig, you need to provide notice to the RGC within 48 hours, okay, which is the notification arm of the Dig Safe Board, okay? You may be required to do education courses in lieu of a fine, but you're probably going to have to seek that in the administrative proceedings. So contact us if you get into a Dig Safe Act dispute. I think we're coming up on the last case here. This was a pay when paid problem on a public, I believe a public works. It's North Edwards Water District. I wanted to highlight this one too and talk a little bit about pay when paid. I know that there's a lot of contractor confusion around pay when paid. This particular case, there was a pay when paid provision, and the fight is over whether that pay when paid clause would be enforceable in the contract, where there was a payment bond statutory remedy for the subcontractor. And the answer is no. The pay when paid does not apply in the payment bond claim. The subcontractor can seek their payment bond claim, and in addition to whatever their contractual remedies are on the pay when paid. The other thing that I will say here, even though it's not necessarily part of the Crosno versus Travelers case, is that the kind of consensus among construction attorneys that deal with this issue, in my sense of it, is that the reasonable time provisions. What is a pay when paid clause? It's whatever the reasonable time to wait, to distinguish it from a pay if paid clause, which is illegal, okay, not enforceable. The reasonable time should be defined expressly in the contract. If it's 6 months, it's 90 days, whatever that period of time that we give the contractor the right to pursue the claims, you should be drafting that accordingly. and defining the reasonable time. You do not want the courts to be doing it, or a jury. That would be my, advice typically if I'm given contractors contract to review and update. So that's it. Our phone number is 805-306-1100, extension 128. My name is Stephen M. Sanders. I'm at your disposal, and if we got any questions, I'm happy to answer them. There's a little bitty button there up in the right portion of the screen that you can click on in order to type in a question. In other seminars, I've had a difficult time finding it, so I'm trying to point to it. If you have insurance questions, there were a couple of changes in insurance law. We have Jeff Pointer at my office, who is a very capable coverage attorney, used to work for State Farm, did insurance defense law, is very knowledgeable in that area. We can also refer you to insurance brokers that are very construction experienced. So if you need a broker or agent, feel free to reach out to us and we'll make recommendations. Yeah, my take, this is a question, is the new right to cancel, the 5-day right to cancel for seniors, can it also be waived for emergency work? My understanding is that it applies to the 3-day non-emergency right to cancel, and it extends the 3-day to 5-day for seniors, but there's a 7-day emergency right to cancel, which is still in effect. And typically when I do home improvement contracting contracts, I attach both the 3-day, which now would include a proviso for seniors, for 5-day, and I just take the statute language and dump it in, include it in the proviso for the 3-day. And then I also provide a separate 7-day, because I know that a lot of my contractors are involved in emergency work or where there were emergency disaster zones, because a lot of these folks are doing fire renovations, renovations. So the answer is, I don't know that you're waiving it. It's just a different remedy. It's the 7-day remedy because it's been declared an emergency, disaster zone, et cetera. Or it may be that it applies for other reasons that are exigent. I'm happy, if you want to call me, we can discuss those in more detail. I'm happy to, take you through the 3-day, the new 5-day, and the 7-day law. Okay, I have not had any other questions. We'll give it another minute here. If I don't have anything else, then we'll call it a day. Okay, so if you need the materials or any follow-up, you can reach out to our office. Again, it's 805-306-1100, extension 128, or you can email me at the email address on the screen, Stephen@thegreenlawgroup.com. I look forward to talking to you and helping you out if you get in any situations. Thanks a lot. Appreciate it.